Hello, everyone. I don't have my traditional background today. Just trying to get that figured out, but technical glitches. Every once in a while that happens. I am presenting today from the Carpenter Law Firm studios, my office, and I've got a presentation today about how not to end up in court. And I don't have any magic answers for avoiding court, but I do have some interesting information. So, how to stay out of court. This is a bit of background and a few interesting nuggets along the way. So, let's get started. One of the things about the Carpenter Law Firm, we tend to start on time, at least we try to. So, let's jump in. Court is two-faceted. The association as plaintiff, to get the names right, the plaintiff is the one initiating the lawsuit. The defendant is the one defending. That's sometimes how we can keep the nomenclature, the labels correct. The plaintiff, that doesn't always tell us that that's the initiator of the lawsuit, but the defendant is easy. It's the one defending. The one against whom the allegation is made is the defendant. You're defending the allegation. You're the one who's been accused of something. So you're the defendant. You're defending the allegation. So there's two ways to look at this. When you're in court, you are either the one initiating the lawsuit, association as plaintiff, or association as defendant. The association has been sued. We are talking about civil claims, not criminal claims. Generally, when we talk about the association being caught up in court, caught up in litigation. Now, what do we mean by the word litigation? Litigation is an umbrella term for being involved in a lawsuit. The whole mess of the lawsuit itself, the process of the lawsuit, the back and forth, the rules, the process of being embroiled in the lawsuit, we tend to call that litigation. We're not talking about criminal claims, although that happens. Here's some criminal claims I've been involved in over the years. I've been accused of a crime myself, but my clients, embezzlement. There are a number of embezzlement crimes that happen in associations. I hesitate to tell you the most creative ones. Plant any ideas in your minds about how you could embezzle, because some of these are actually really easy. But I will give you two examples, perhaps things to watch out for as directors or professional community managers. One of the most creative, but ultimately it didn't work. A manager had an assistant. The community had 30 City of Phoenix water meters that were separately invoiced to the association. And the assistant employee also lived in the City of Phoenix and had her own City of Phoenix water meter bill. And she saw all of these separate City of Phoenix water meter bills that came to the association. And apparently had the bright idea, well, I'll slip my personal City of Phoenix water meter bill in with this stack of 30. And the association will pay it and never figure it out, that it's my personal water meter bill. I mean, geez, the association is paying 30 of these. Why not 31? And of course, it was discovered. And so that's a form of embezzlement. Back in the 90s, when this happened, an average City of Phoenix water meter bill might have been $30 to $40. There was an embezzlement of $30 to $40 a month. That's an embezzlement. A higher form of embezzlement is for a community manager to create Carpenter Landscaping LLC, obtain an EIN number, open a bank account at Bank of America, and submit invoices created at QuickBooks.com for services rendered. Perhaps even create a contract for Carpenter Landscaping LLC and submit invoices that are then paid by the association. When there's an audit, there's a contract, there are invoices, and there is a real LLC at the Arizona Corporation Commission. There's an EIN number, employment identification number, taxpayer ID, whatever you want to call it, and there are invoices. In that sense, it checks out. There's even a contract. The contract is signed by the manager as managing agent for the association. That's embezzlement. So today's talk is not about these criminal claims, embezzlement, assault. I've had plenty of clients where board members are engaged in assault. That's hitting someone. Actual physical altercations, battery, another form of hitting, or theft. Someone breaks into the clubhouse and steals the TV off the wall. These things have happened. So we're not talking about criminal claims, although they do happen. We're talking about avoiding these civil claims, going to court and seeking money or other relief from a court, whether the association is the plaintiff initiating the lawsuit or the association is the defendant, where someone or a company or other entity has sued the association seeking relief from the court against the association. Another thing about court is that we lawyers use the word judge and court as synonyms often. We seek relief from the judge, we seek relief from the court, and we use these words interchangeably. The court and the judge are almost always synonyms, and judges don't mind. The judge might, he or she, refer to himself or herself as the court, even though we think of the court as the place, the room, the building. The judge and court are often synonyms. So here are some claims that the association might assert as the plaintiff. Again, as background, suing a developer, this can happen. What are the claims that happen from time to time? Failure to fund reserves, failure to pay assessments owed, such as a subsidy or other assessments that are owed by a developer from the period of developer control at the beginning of an association's existence. And then the one that some lawyers want in order to take a case on a contingency, the construction defect lawyers, for lack of a better term, is to sue a developer for failure to adequately construct an asset or component that the association must maintain over the long term. We call this the construction defect claims, and there are lawyers, you probably know who they are, some of them, that want to take these claims on a contingency fee to sue a developer. These are claims against a certain species of defendant where the association might be a plaintiff. The association is not entirely in control of whether these claims can be avoided. The developer plays a role in ensuring that these claims cannot be asserted. Here's another one, suing a vendor. The association might find itself in a position where it feels like it needs to sue a vendor. Why would this happen? A failure to perform to the contract specifications or scope of work. An association might hire a roofing contractor, and it might be multiple buildings. It might be a $1.5 million contract. And when it's done, the contractor might have failed to do the work according to the specifications and scope of work in the contract. Might have to sue the vendor to, to, to obtain relief. There may be overcharging. There might be payment issues. Might have to sue a vendor over that. And then the type of claims or the association might be the plaintiff, the classic, the one we deal with every day as association lawyers, is suing an owner. Why do we do that? Well, we do it because of covenant violations, CC&R violations. Sometimes we use the word covenant. Sometimes we say CC&Rs, declaration, whatever word you want to use. The most common, failure to pay assessments. If someone fails to pay assessments, we may foreclose the assessment lien, or we may sue the owner for a personal money judgment and then garnish wages or garnish a bank account, garnish a rent payment, whatever the case may be. But a failure to pay assessments or a failure to comply with a non-assessment CC&R provision. Someone paints their house pink without architectural approval. Someone puts a gazebo in their front yard without architectural permission, parking their RV in the front yard, etc. These are all covenant violations, and we may sue an owner for any or all of the above. So that's where the association finds itself as a plaintiff in a lawsuit, litigation. Avoiding that is not entirely within the association's capability. Again, just like with the developer plays a role in avoiding that lawsuit. A vendor plays a role in avoiding that lawsuit, and the owners collectively play a role in avoiding that lawsuit. I often say to clients and my colleagues here at the law firm, the association governance structure from a legal standpoint is really based on the honor system. You may think you left that behind when you left junior high or high school, the last time that some part of your life was based on the honor system. The honor system is this idea that everybody complies because it's expected, and the basic understanding in a governance system is that we all comply because we decided it's in our best interest to do so. And we do it out of fairness to each other, to those of us that are in the system. The HOA world, planned communities and condos in Arizona, and actually throughout the country, is that the whole system breaks down if we do not have voluntary compliance by, and I'm putting a number on it just to make a point, by over 95% of the owners. And that's just a number to make a point. If we have more than 5% delinquencies or 10% delinquencies, those of you who are professional community managers would have a better sense of this. But at a certain point, a delinquency rate above a certain threshold, and I'm not in a great position to say, but let's put a number on it, above 10 to 15%, the system breaks down. The budget doesn't work if more than a certain number of people are delinquent. There's no way for the budget and the association to work if the delinquencies are too high. So we end up in a situation where the honor system is required for everybody to pay. The same thing is true of covenant violations on the enforcement side. If everybody stops complying, nobody would comply because everybody would look around and say, I'm not going to comply until that guy complies and that guy complies and everybody else complies. The only way the system works is if we have rampant compliance, radical compliance by just about everybody. So we have to have the honor system where everybody complies because everybody, 85, 90% of the people all the time believe that it's the right thing to do. They comply because they want to. So let's go to the association as defendant. Sometimes associations are sued by a developer. Perhaps the claim is failure to properly account for assessments or a subsidy. Sometimes vendors sue failure to pay. The association may be accused of breach of contract. But most commonly among these three species of potential plaintiffs is being sued by an owner. We see lots of different claims: failure to comply with the statute, such as you failed to comply with the open meeting requirement, you failed to comply with the books and records statute, things like that. Failure to comply with the governing documents, various claims there depending on what the documents say, and failure to comply with the removal statute. I'm dealing with that matter right now this week. A client is trying to comply with the removal statute amid threats of litigation if the association doesn't follow it just right or just the right way according to the expectations of the petitioners. I mentioned the books and records statute, the open meeting requirements, etc. So there's a lot of challenges and potential potholes for the association to sink into as it's navigating the road of good governance. And so there's a lot of ways for the association to end up in court as a defendant. And really, this is where we have the best opportunity to avoid ending up in court, which is the theme of today: how to stay out of court. How do we avoid being sued by an owner? And the broader question is there anything we can do to avoid being sued by an owner? Or are we always playing whack-a-mole for everything that ever comes up? Or are there some people who are going to sue you regardless? Perhaps that's the better question. There are 4 courts, I call them tribunals here in this PowerPoint slide. 4 tribunals in Arizona, 4 ways to be sued. And we'll start with the easiest one, which is small claims court. I have a client right now that's been sued in small claims court over a wrongful notice of claim of lien, and the claim was brought in small claims court, justice court, superior court, and the Arizona Department of Real Estate. The Arizona Department of Real Estate is not a court. It is an executive branch agency, tribunal, that has dispute resolution powers. I'm critical of it, and we'll get to that in a few minutes. Let's go through them one at a time, and I'll explain your exposure. Small claims court. By law, lawyers are prohibited from small claims court, prohibited from advocating for clients. If I have a dispute with someone who, let's say, installed a garage door opener at my house, it's not a true thing, but let's say it did, I can go to small claims court and make a claim against the guy who installed the garage door opener at my house on my own behalf, even though I'm a lawyer. But I cannot represent a client in small claims court. I am prohibited. The dispute in small claims court must be for money only and be valued at less than $5,000. That's the jurisdictional limit. So using my garage door opener example, if it's a $3,000 dispute and I'm representing myself, Scott Carpenter versus John Doe, handyman, garage door opener disputes, $3,000. I can go to my local small claims court and sue the guy for the $3,000 dispute. You could too. But if your association is sued by an owner for $3,000 and you call me up and you say, Scott, can you represent the association in this small claims court dispute? The answer would be no, I cannot. I cannot make an appearance in small claims court on behalf of Green Acre Association that's been sued in small claims court by an owner for $3,000. There are things we can do. We can move the dispute to justice court, and I can represent Green Acre HOA there, but I cannot make an appearance in small claims court. An officer of Green Acre can represent the association in small claims court, or other non-lawyer designated agent can represent the HOA, such as a management company employee can handle it in small claims court. So there are options. I can't do it. No lawyer, member of the bar in Arizona can appear in small claims court and defend Green Acre in that hypothetical case. But there are options. The president can do it, management company can do it, but the lawyer cannot do it. The lawyer can move it to justice court. And of course, beyond that, when there's a claim against the association has to decide whether to involve its insurance carrier, which is a different question. Do you defend it on the merits and run the risk that you lose and owe the $3,000, or do you involve your carrier and have the risk that you pay the deductible on your directors and officers insurance or your general liability insurance? And now you have a claim against your policy or policies, which is a different issue entirely. You got to calculate all of that. And to consider all of those insurance issues, you might be paying your regular lawyer hourly, and now the expenses have gone up even to consider the complexity of the insurance issues. There's no cheap or free way to go about getting sued in small claims court. Justice court. Lawyers can appear, we go there all the time. The dispute must be for money only and must be valued at less than $10,000. Small claims court and justice court, same building, same courtroom, same judge. A lot of people don't know that. It's funny because when something's in small claims court and you move it to justice court, it's the same judge, same courtroom, same court employees, same judge, justice of the peace that's elected by the citizens and people who vote in the district where the justice court is. But the judge, the justice of the peace, sits and convenes the justice court, sits and convenes the small claims court, hears cases, and just the jurisdictional limit is different. The case numbers are different, but it's the same building, the same courtroom, the same judge, justice, however you want to think of it. Superior Court. We have 15 counties in Arizona. Every county has a dedicated Superior Court. Navajo County Superior Court, Maricopa County Superior Court, Cochise County Superior Court, Greenlee County Superior Court, Yuma County Superior Court. Lawyers can appear. The dispute can be for money in excess of $10,000 and for what we call non-monetary relief, such as an injunction or declaratory relief, where the judge declares the rights of the parties, such as did the board breach the CC&Rs? Should there be an injunction? An injunction is a court order. Tear down the gazebo in the front yard that you put up without architectural approval. Paint the house an approved color. Stop parking the RV in the front yard. These are injunctions. These are court orders. We have to go to Superior Court for that. We cannot get that court order in justice court. And by the way, we can't get it at the Department of Real Estate either. Preview of the next slide. The only place we can get a court order that says, stop violating the CC&Rs, stop building without architectural approval, paint the house back to an approved color, stop building without architectural approval. These court orders can only be obtained here in Superior Court for the county in which the association exists. Mojave County for Lake Havasu, Yuma County for Yuma, Maricopa County for Phoenix, Scottsdale, Chandler, Tempe, Gilbert, etc. Now, we lawyers know which county to go to, but that's my point. We've got to be in the right place. ADRE, Department of Real Estate. The association can go there. Owners can go there as well. There's a filing fee. The question that can be posed by either the association or an owner is, did the owner or the association violate a statute or regulation in the statute that governs an association, or did the association or the owner violate the governing documents? It's pretty simple binary questions. The owner files the adjudication by the administrative law judge, employee of the executive branch, Department of Real Estate, executive branch agency. The question posed by the owner is, did the association violate the statute? Did the association deny the owner books and records? Did the association violate the open meeting statute? And the answer might be yes. The answer might be no. That's the relief that can be obtained at the Department of Real Estate. Essentially, yes or no answers to questions posed. Did the association violate a statute? Did the association violate a governing document provision? And almost always it's the owner filing at the Department of Real Estate. The associations rarely go there to answer these questions because, as you can tell from bullet point 2 and bullet point 3 on the screen, ultimately, from an association perspective, answering these questions is not that helpful. Why incur the attorney's fees to go to the Department of Real Estate to answer this question, yes or no, if you're going to spend the money on attorney's fees to go, I'm going to use a word I mean, but don't mean, litigate at this tribunal when you could go litigate here and actually get an injunction. That's why lawyers like me in particular, and other lawyers that do what I do, represent associations for a living, rarely advise clients to go here to this tribunal, because what's the point of this? At the end of the day, you ask this tribunal this yes or no question. You did not get a court order. There's now no deadline with any teeth. There's no court order that says, tear down the gazebo in the front yard that you erected without permission. There's no court order that says, stop parking the RV in the front yard. And the other examples I gave. Not very satisfying. And in addition, and this is not the point of this webinar, this process is unconstitutional under the Arizona Constitution. I litigated this question a number of years ago to the Court of Appeals and the Arizona Supreme Court. And the courts said that this process is, in fact, unconstitutional under the Arizona Constitution. For those of you who are curious, I'm not going to leave you hanging. We have in our state, under the Arizona Constitution, something simple called the separation of powers. The executive branch does executive branch things, the legislative branch does legislative branch things, and the judicial branch does judicial branch things. This is a high school civics concept. The legislative branch passes bills, the executive branch does executive branch things, and the judicial branch does judicial branch stuff. Essentially decides disputes in the judicial branch. The courts do court things. And what the executive branch and the judicial branch did when they passed the bill that created this dispute resolution process in the executive branch is the legislature and the legislative branch and the executive branch got together through a bill passed by the legislature and signed by the governor and said, these two branches got together like two siblings picking on a third sibling. I have two sisters, so I know how this works. And if you've come from a three sibling household in your family of origin, you understand three sibling dynamics. So the legislative branch and the executive branch got together and said, we don't think the judicial branch is doing a very good job of resolving HOA disputes. So we're going to get together and pass a bill that says the judicial branch is doing a bad job resolving HOA disputes. So we're going to take HOA disputes and plop them down in the executive branch. But as it turns out, again, a parenthetical point here to satisfy those of you who are curious why I'm saying this, if anybody is, there's case law in Arizona that says the executive branch can resolve disputes if it also regulates. So we know that the registrar of contractors resolves disputes. There's an administrative process to resolve disputes with contractors. The reason that works is because the executive branch also regulates contractors. But when the legislative branch and the governor got together and said the executive branch is going to resolve disputes in condos and planned communities, the legislature and the governor did not also give the executive branch the ability to regulate HOAs, planned communities, and condos. So the dispute resolution in the executive branch was inappropriate and unconstitutional. That's what the court said. But the next year, the legislature put the regulation back in the executive branch and said, well, we understand the court cases. We understand the court case. But the dispute resolution is regulation. But that's not accurate. And so we're in a situation now where the entire process is unconstitutional, and the next person or association that is aggrieved and upset by a ruling could take it up to the Court of Appeals and would likely win and have the whole process thrown out again. But the incentives haven't been there for anyone to do that because these decisions are not that problematic. They're simply questions answered yes or no. And to this point, no association that has been on the receiving end of a bad ruling has felt, as I believe, has felt like it's been bad enough to spend the money. It's not cheap from an attorney's fee standpoint to go to the Court of Appeals and the Arizona Supreme Court to have the whole process thrown out. So a longer explanation than perhaps necessary to point out why the process is unconstitutional. But some people go there, but in most cases, the D&O insurance covers it. So, what are the insurance considerations? Well, some board members sometimes confuse association insurance with the teenage driver scenario. What does this mean? Well, I raised three daughters when they were teenagers, and when you if you've ever had a teenage driver, and you get the dreaded phone call, "Hey mom, hey dad, I'm at Fry's and I ran into somebody with the car." Immediately, I better drive there quickly and try to settle up with the other driver. We don't need a claim on our insurance with a teenage driver. It's the last thing you want. And what ends up happening sometimes with board members is they think any claim on the association's insurance is going to be a death spiral for renewal and premium increases. And sometimes that's true, especially in property and casualty, but not always true with directors and officers. So we're concerned about claims, but it is not always the case that every claim causes premiums to go through the roof. Let's remind ourselves the three types of insurance: general liability, trip and fall on the sidewalk, property and casualty, hail damage to the roof of the clubhouse, and directors and officers, all lawsuits and claims against the association and board that are not in the general liability and property and casualty categories. So anytime the association is sued, whether small claims, justice court, superior court, or DRE, Department of Real Estate, may be covered by D&O, we should try. And in fact, the D&O policy, directors and officers policy, probably has language requiring the association to inform the carrier of all claims. Even if you don't intend to take advantage of the coverage, you have an obligation to inform the carrier of all claims regardless. Claims history matters, but my view is that you have the insurance for a reason to tender the claims, particularly on the D&O. I've had clients that have had significant D&O claims and then they're renewed, or they find another carrier that writes the insurance without any trouble. But this idea that every time there's a claim, we're going to be uninsurable or the deductible is going to go through the roof, sometimes that's true. I share the concern on property and casualty. I share the concern on GL, but on D&O, it's not always true. Don't take my word for it. Every underwriter has the right to do their own thing, and your own experience is probably better than mine. But I've had plenty of clients that have had significant D&O claims that seem to be able to find insurance the next year and in following years. All right, so let's talk about the standards of director conduct. And this is sort of the get out of jail free card for avoiding litigation. There's a statute in the Arizona Nonprofit Corporation Act that tells directors exactly how to make decisions. It's ARS, Arizona Revised Statute, Section 103830, and this is the general standard for directors. It says that a director's duties, including duties as a member of a committee, shall be discharged. That's a synonym for must be discharged in three ways: in good faith, with good intentions, with the care an ordinarily prudent person in a like position would exercise under similar circumstances, and in a manner the director reasonably believes to be in the best interest of the corporation. Directors must do all three. It's not optional. Have good intentions. have the care of an ordinarily prudent person in the same position under similar circumstances and act in the best interest of the corporation. This shouldn't be the hard part. This is supposed to be the easy part. And then the good news is that directors are entitled to rely on information and reports prepared by, focus on number two, lawyers, accountants, and other people as to matters the director reasonably believes are within the person's professional or expert competence. A roofing consultant, an asphalt consultant, a professional community manager. When the board member relies on experts, lawyers, accountants, anyone that the director reasonably believes is within the person's professional or expert competence, the director's in a good position. Or a committee, if the director reasonably believes the committee merits confidence. So subsection B is important. Call this the safe harbor. We've come to call this the safe harbor because that's what it is. The word safe harbor is not in the statute. And then subsection D is awesome because it says the director is not liable for actions the director takes in compliance with this section. That means 1038:30. If you're doing subsection A, you're not liable for any actions. The director is not liable for any actions that the director takes. And if the director is acting within the safe harbor in subsection B, the director is not liable. That's the first sentence. It's not highlighted. In any proceeding commenced under this section, that means lawsuit. That's the second sentence, not highlighted. In any proceeding commenced under this section, a director has all of the defenses and presumptions ordinarily available to a director. Then highlighted, a director is presumed, the law assumes that in all cases the director acted, failed to act, or otherwise discharged the director's duties in accordance with subsection A. In other words, the law assumes from the jump, from the gun going off in the 100-yard dash of this legal claim, lawsuit filed against the board members, the law assumes that the board members complied with subsection A. That's the starting point, is that the board members did that good faith thing in subsection A. The starting point is the law assumes that the directors did 1, 2, and 3. It's an amazing act of legislative gift. In a lawsuit, the starting point is that the directors are given the gift that their conduct is assumed to have been within A, 1, 2, and 3. It's pretty cool stuff. And then the red part, the burden is on the plaintiff challenging the director's action to establish by clear and convincing evidence facts that rebut the presumption. The presumption is that the directors acted within subsection A, 1, 2, 3. The owner who's suing the board members has to prove by clear and convincing evidence that the directors violated subsection A, 1, 2, and 3. And frankly, a lot of lawyers don't even know this. Lawyers who represent owners suing directors, they forget about this. It's an important baseline of expectation that an owner suing the association doesn't get to just say, hey, the board breached its duties. No, the board is presumed to have met its duty, subsection A, and the owner suing has to establish specific facts by clear and convincing evidence. Real quickly, a bit of law school 101 here. In criminal court, if you've ever been a member of a jury, in order for the prosecution to win a verdict of guilty, the prosecution has to convince the jury beyond a reasonable doubt that the defendant is guilty of the crime charged beyond a reasonable doubt. In civil court, on a generic assessment collection case, let's say, for the association to win, the standard of proof is what we call a preponderance of the evidence. And in law school, professors say, well, that's more likely than not. Think of it as like 51%. There are three standards of proof in the law. Beyond a reasonable doubt, we know that, I just explained that. That's in criminal court. And then standard civil claims, preponderance of the evidence, more likely than not, 51%, let's say. And then the third standard of proof is this one here that's likely new for some of you, clear and convincing evidence, which is in between the two. It's not beyond a reasonable doubt. It's not as low as preponderance of the evidence. It's in between. Should we call it 75%? What is beyond a reasonable doubt? Is that 90%? Is it 95%? I don't know. I'm not a criminal lawyer, but it's somewhere in that range, perhaps. But this is a significant hurdle for a plaintiff to overcome, clear and convincing evidence. But often it's overlooked. It's a great tool for lawyers defending associations to keep in mind when owners are bringing claims. So bottom line, statute says have good intentions, act in the best interest of the association, and the manner a prudent director would under the same or similar circumstances. If a director does that, the conduct is presumed to be proper. Don't forget about the burden of proof. To stay out of court, let's stay within the standard of conduct. Okay. So how do we stay out of court? Well, let's oversimplify for a moment, and I don't mean to be obtuse about this. It'd be nice if we could have owners who don't violate the covenants. That's not going to happen. We talked about the honor system. We also know that it would be nice to have owners who don't sue you, but that happens. It'd be nice to have perfect vendors, but we can have directors who endeavor to stay within the duties. That helps a tremendous amount. I also believe, and I haven't mentioned it yet, that we need to have directors who understand the need to raise the assessments every year. Does that keep you from being sued? Not necessarily, but it's a good governance habit that would have put associations in a better governance posture today if that had happened over the last 10 to 15 years. It wouldn't necessarily keep us out of court, but we'd be in a better overall financial and governance position if we had done that. But quick parenthetical there. Is this impossible? It may be, but over my now 31 years of representing community associations in Arizona as my exclusive area of law practice, I have come to believe that every association will have a litigation event eventually. And by litigation event, I mean a big lawsuit that will kind of rock the association, rock the board and the membership. Sometimes you can see it coming. It might be a big lawsuit brought by the association. It might be a lawsuit brought by an owner. It might be a construction defect claim brought by the association. But the kind of litigation event that everyone in the association knows about and cares about, eventually it feels like every association, no matter the size, no matter the age, will have a litigation event. Here's an analogy. It's like a 100-year flood. We have 100-year floods here in Arizona. That doesn't mean they happen once every 100 years. It's a volume of water description. And it seems like we have a 100-year flood every 3 or 4 years, depending on where you are in the state. And I don't mean that every association is going to have a litigation event every 3 or 4 years, but every association, in my experience, has had or will have a significant litigation event. And I'd love to have a magic way to avoid it or to stay out of court. But I guess I just essentially admitted that I don't know that there's any way to do it other than for the board to do its very best to discharge its duties day in and day out the best that it can. Because you have to collect the assessments, you have to enforce the covenants, but we can endeavor to have the best relationship possible with our vendors and hope that that keeps us out of court with our vendors. I have tried to figure out why I cannot get the Q&A and the chat to work, and I apologize for that. For some reason, I can't seem to get that to work. If any of you have questions, feel free to email me at scott@carpenter.law. I apologize that I have not been able to master. I should be the master of Zoom, but I can't seem to figure out why the Q&A and the chat is not working. And I apologize for that. No, it is working. I see it. Okay. Q&A is working. Q&A is working. If you have any questions, feel free. A couple more minutes before our 1 hour is up. Okay, someone asked, do all CC&Rs have mediation before court clauses? No, they don't. Some do, but they do not all have that. Do I recommend mediation? I do recommend mediation before we go to court, absolutely. Sometimes it does have a good success rate, and the person asking is someone I know well, president of one of my clients, and we did spend time in a mediation that did resolve an issue before litigation. So I definitely recommend mediation before going to court. It can be very successful. Someone mentioned they see advertisements for sue your HOA on Facebook. Is this valid? Well, people are chasing business. Lawyers are chasing business all the time. And I think there's plenty of lawyers, just like the billboard lawyers along I-10 are chasing clients. There are people chasing clients to sue HOAs, and they know that there's insurance. They know there's D&O insurance, and they're hoping to, lawyers are trying to make a living just like anybody else, and lawyers are trying to find clients to help them make a living, save for their kids' college fund. Those are valid in the sense that they're looking for homeowner clients to sue HOAs and make a living just like anybody else. So yes, I do think that there are lawyers that are, I'm going to use a word I mean, but I don't mean, they're trolling for individual owner clients in the hope that they can get something going and sue an HOA. The HOA will tender the D&O, and then eventually there will be money for a settlement. Yes. All right. What is the average cost of seeking an injunction against an owner for a cease and R violation? If the owner fights back extensively, it might be the cost in that situation. That's a great question. You know, those court cases tend to be hourly, and as you can imagine, if the owner hires an attorney and fights back hard and extensively, it could be thousands, thousands. Some of the monthly invoices, you'd hope it could be cheap, but the monthly invoices could be 5 to 10,000 a month. Hate to say it that way, but it's expensive. What's a what venue is appropriate for a case where the HOA is in conflict with a neighbor that is not part of the HOA? The venue would be Superior Court. Um, and that can be tricky depending on what the claim is. If the neighbor is being loud or difficult, those can be particularly challenging. Figuring out what the claim is, what's the cause of action, tortious interference with quiet enjoyment of property. The anonymous attendee who's asking that could be kind of challenging, or if the neighbor will not pay for an easement, finding a mandatory easement or an easement by necessity. Those are somewhat challenging cases. I've definitely handled those over the years. That can be challenging, absolutely. All right, there was one more that I thought was interesting. Let me just try to find it here. My camera is scaring. Just give me a second here. Oh, mediation. It's a question. Mediation would not be practical for lawsuits involving delinquency, correct? Actually, that's not true. I've had a lot of successful mediations over the years where the justice court has mandatory mediation for delinquency cases, and the mediations have been, I've had a lot of successful mediations over delinquency cases, and you'd be surprised how often sitting down with a delinquent owner can result in a settlement. So I'm a big believer in mediation. Part of the problem we have with mediated settlement of delinquency matters is that they often result in payment agreements. And what ends up happening is the owner has an optimistic view of their ability to keep the payment agreement. They say what they agree to what they think the association wants to hear. One of my colleagues here at the law firm, an attorney named Keegan Klein, and I were just talking about this the other day, where the client needed a 6-month payment plan for it to work on the client's side, our client's side. And the owner wisely said, I can't make that work financially. And the owner said, I can only afford the amount of money per month that would stretch it to 24 months. Well, we knew that the court would not keep the case going for 24 months. So we had to go back to the owner. We were already in a foreclosure case, and we had to go back to the owner and say, no, that won't work. We're just going to have to proceed with the foreclosure and go to sheriff's sale. And then all of a sudden the owner said, well, I could afford the amount of money per month that would be 8 months. We went back to the client. The client said, okay, 8 months is okay. We knew the court would keep the case alive for 8 months. That if they miss one payment, we go immediately to sheriff's sale. So what we worry about with mediation in delinquency cases is that the owner agrees to a number that they can't afford on a monthly basis. I mean, remember, the owner got into trouble by not paying $99 a month in assessments. And now they're going to agree to $800 a month now that the attorney's fees are factored in to avoid the foreclosure. So we worry about that. But Ms. Anonymous Attendee, that's what it says on my screen. I like mediation for any dispute. It tends to work pretty well. All right, we're at 62 minutes, 63 minutes. I appreciate you all joining me today. And as always, look forward to sharing more of these as the end of the year and the next year. I'll get my schedule out soon and appreciate your time and attention today. Happy that you've joined me. Thanks.